Good evening, everybody. I'm delighted that you're here at ICSID tonight, and we are so pleased that you have. Thank you. We are so pleased that you have come and joined us tonight to remember our friend and our colleague, Johnny Veeder. I know that all of us have our own memories of Johnny, but I am sure all of you have the number one memory that I have, which was that he just filled a room when he was in the room. You knew he was there, whether he was telling funny anecdotes or if he was sharing a problem that the ICSID rules had to be changed right away because this didn't work, or maybe telling you something about history of arbitration that you had no idea about. But whatever it was, my recollection is just that he completely filled the room and had so many interesting sides to him. I often marveled at how one person could have so many diverse sides and all of them so expert. I used to think, I don't know, did they teach this in British boarding schools or something? Because I have to go home and read and learn and remember these things a little bit more. But as you know, he was quite an amazing person. He was especially important to our world at ICSID. In the beginning, he had 6 cases as a respondent nominee, 6 cases as a claimant nominee, and then chaired 21 ICSID cases in a row. And in fact, chaired 45 investor state cases. So that is quite a legacy and clearly shows you that his gift was evident very early on in his career. He presided with intelligence, collegiality, a lot of pragmatism, and a lot of grace. And I think the main mark of that is that I know that no party who had Johnny as a president, whether they were doing well or poorly in the hearing, ever came out of a hearing feeling that they had not been truly respected, heard, occasionally challenged, but that they had had a good hearing. And that, of course, is one of the ultimate pieces of praise for somebody who is a presiding arbitrator, and we always heard that with parties who had Johnny as their president. I know myself and my colleagues here at ICSID love to work with Johnny, and we enjoyed it, but we also learned something every time and became much better lawyers. And I know I certainly benefited from his advice, especially in the beginning of my tenure, and I'm truly grateful for that. So tonight we thought we would get together a number of counsel who will all talk a little bit about different parts of Johnny and different aspects of his character and their recollections of him. So we have first Sam, who's going to talk about Johnny and his writings, and a bit about him as a teacher of law. I have to say, I remember one of the first things I did was send him a letter saying, Professor Veeder, and I got told that do not make that mistake again. And I remember, So it was clearly something that he very much admired and respected. And I'm going to look forward to hearing that from you, Sam. Then Andrea Menaker is going to talk about how Johnny changed the field. But something as important, I think, is that he stood up for what was good in arbitration and said what should not be changed and what we had to protect in our field. And I think that's a really important quality that contributed to the discipline. Toby's going to talk about Johnny as a person and as a mentor. And Toby had the good fortune to work with him on a number of projects, so he's very well suited for that. And Lucy's going to remind us of Johnny's incredible affinity for the history of arbitration. And if you did not know the word Lena Goldfields before you met Johnny, you knew afterwards. Another thing we all learned, and it was wonderful. We've allotted a good amount of time at the end of this because I know a number of you have your own recollections that you'd like to share. And so as opposed to a traditional Q&A type session, I would hope and encourage you to actually share your memories or your thoughts that you'd like to after we've had our panel talk. And then I'm going to very promptly at 7:30 insist that we go to the reception area and that we raise a glass. And after that, if there are still stories untold, I encourage you to please share them some more, and we can have a nice evening together. So thank you. Sam, why don't you take it away from here?
Thank you very much. There we are.
Just like a hearing.
It's just like a hearing. Thank you, Madam President.
Johnny would have made the same mistake.
Yes, exactly.
He would not have pressed.
Okay. Madam President, members of the tribunal, thank you very much. Yes, so thank you. So the purpose of today is to focus in on Johnny's brilliant mind, and not just to focus in on the fact that he was, as everyone I think in this room will remember, a truly wonderful human being. And we want to look at Johnny's works as an arbitrator, as a truly great thinker. And if we can have slide 1, you can see him as a truly great thinker with a slightly passionate love for legal research, and particularly in slightly esoteric fields of law, which at one point indeed led to him having to interview Lenin, as you can see, back in 1922. But also as a teacher at King's College in London, loved by 2 decades of master's students. And that's where I'm going to start. I'm just going to start by a photo. This is just slide 1. The next slide, please, which just shows a photo which may come, it may happen, like that, which shows a photo of Johnny with that just a wonderful twinkle in his eye, with the future marine biologist that we can see over there. And that wonderful twinkle meant that when it came to lecturing was going to be wonderfully enjoyable and passionately interesting, as well as being suddenly relevant, suddenly important. So when it came to lecture 1, it wasn't, here is Article 25 of the ICSID Convention. Instead, it was Johnny's wonderful arbitrator quiz, which everybody in this room will get through very, very quickly. Question 1, name an arbitral nominee who has won a Nobel Prize. The answer is, of course, everyone knows, silence. He would be very disappointed. None other than, of course, Albert Einstein. If you want to compete, by the way, the right-hand side against the left-hand side, please do, because the questions actually get a little bit more difficult. But Johnny used to love how the fact that the Soviets proposed Einstein, the British said no, because that's what respondent states always do. They just say no to whoever the other side has proposed, and vice versa, of course. Name an arbitrator who was a saint, a nice easy one. No, it's so disappointing. Johnny would be very, very unhappy. Of course, it's St. Maxime the Greek, who in the 16th century went, of course, to Moscow to resolve the dispute, absolutely important dispute, as to whether monasteries could own land or not. Then name 10 female arbitrators, other than Gabrielle Kaufmann-Kohler. Now, I think everyone in this room could do that, but to make it a little bit more tricky, here's another of Johnny's photos, which is, who is this? No? Okay, it is in the World Bank building, so it's in the good old ICSID days. The wind is 78.7 miles an hour, and of course, the perfect hairdo there is, Toby.
This is Brigitte.
This is indeed Brigitte Stern, and of course. But all this had a purpose, because Johnny was saying to his students, listen, the names really matter. You've got to get to know these people, because we're in a system of law where it really matters who wrote the award. And so he would get the students to focus on the names, and he would say, X, if the award is by X, it's really, really good. And if the award is by Y, well, perhaps this isn't quite really their field. Or at least he did used to say that in the days before the lectures were recorded, which he only realised about 5 years after the event. And on the details, of course, Johnny was absolutely superb, whilst at the same time being able to make, even Article 25 of the ICSID Convention and the meaning of investment sound super interesting, and making the students see the issues from the viewpoint of the impoverished Italian pensioner who'd invested in the derivative of a bond, and also to see it from the point of view of the state, who was fighting off a default claim on its bonds. And just because the last point I want to touch on his lecturing is just because it's so funny, is Johnny lecturing in the context of the early cases on Soviet mining concessions, and he was dealing with students who didn't know who Yul Brynner was. So he put up a photo of Yul Brynner, and he thought everyone would know who Yul Brynner is. At least 50% of the current audience will, and nobody could. And he said, Johnny, this is a transcript of the lecture. Now, this is someone you should know. Who is that? Come on, someone must know. This is terrible. He's incredibly famous. One student says, John Wayne. Completely wrong. Okay, The Magnificent Seven. Does that film mean anything to you? The Magnificent Seven? No. Do you know Kurosawa's film, The Seven Samurai? No. Culturally, you are very deficient. This is terrible. These are the two most important films ever made. Well, The Seven Samurai was remade as The Magnificent Seven in Hollywood, and this guy, Yul Brynner, was the leader of the Magnificent Seven, who protects the villagers and saves them from very bad people. Anyway, his father was party to what is called the Tete arbitration. And so Johnny would, of course, guide it back to the important points that he was coming back to. In the few minutes I think I have left to me, if I have any left at all, Madam Chairman will tell me otherwise, I think. I just want to touch on some of Johnny's awards, because he was, of course, the co-contributor, obviously with other arbitrators, of many of the most influential awards that we've seen in the past 20 years. And this is from Methanex in the United States concerning the jurisdictional gateway under Chapter 11 of the NAFTA and many more recent FTAs. And the question is, well, what is meant by relating to? Because the measure has to relate to the investor or the investment. And Johnny rejects, or Johnny and his co-arbitrators, they reject that it can be just affecting, because in this case the test could be met by suppliers to Methanex who suffered as a result of Methanex's alleged losses, suppliers to those suppliers, and so on towards infinity. It may be true to adapt Pascal's statement that the history of the world would have been much affected if Cleopatra's nose had been different. But by itself, that cannot mean that we are all related to the royal nose. The chaos theory provides no guide to the interpretation of this important phrase, and a strong dose of practical common sense is required. And that's wonderful, because that is, if one thinks that Johnny is there holding the pen, as he may well be, it's pure Johnny. It's lyricism coupled with intellectual rigour and a recognition of the need for both legal and practicable meaning. I turn to Plama and Bulgaria very briefly, and early foray by Johnny and his co-arbitrators Carl Salins and Albert Jan van den Berg into the great most favoured nation provision debate, accepting that an arbitration agreement could be incorporated by reference, and you see there clause reading, and then there's the standard word of the MFN provision, cannot be said to be a typical incorporation by reference clause as appears in ordinary contracts. It creates doubt whether the reference to the other document, in this case the other BITs concluded by Bulgaria, clearly and unambiguously includes a reference to the dispute settlement provisions contained in those BITs. And I mention that in particular because actually this was a passage of Plama that was subject to some criticism, because it was said, hang on a sec, this clear and unambiguous test, where does that come from? Does that really come out as part of Article 31 of the Vienna Convention? Isn't it just lifting the bar too much for a jurisdictional provision? But in fact not, and one can see that from no lesser authority than the ICJ, for example, in the Djibouti and France case. As the court has recently explained, whatever the basis of consent, the attitude of the respondent state must be capable of being regarded as an unequivocal indication of the desire of that state to accept the court's jurisdiction in a voluntary and indisputable manner. So, Plummer, I think, was absolutely right. And of course, the current trend on the great MFN debate is very much towards saying that no, you cannot incorporate an offer to arbitrate from another treaty in that way. And that one can see, for example, in the very important Judge Greenwood lecture before EFILA. How many? I've got a minute? No minutes.
1 minute.
1 minute. Just to draw your attention very quickly to 2 or 3 more cases. The Eureka Acmea case, of course, it's absolutely fundamental, been followed again and again and again on the hugely complex question of the interplay between European law, international law, and jurisdiction. Acmea was the first case on the subject, decided with Vaughan Lowe and Albert Jan van den Berg, followed again and again and again by other tribunals and agreed with everybody except the European Court of Justice. Electrabel, another super important case on what is required for there to be an indirect expropriation. And perhaps I'll just finish on Chevron, that hugely complex, life-draining case, but with superbly important parts to it, including, of course, on the meaning of denial of justice. And this very nice description, the tribunal emphasizes that the legal test for denial of justice requires the claimant to prove objectively that the impugned judgment was clearly improper and discreditable, with the failure by the national system as a whole to satisfy minimum standards. There have been many shocks and surprises caused by court judgments in legal history, but without much more, amounting to discreditable improprieties and the failure of the whole national system, such judgments do not amount to a denial of justice. So superbly important reasoning. Thank you, Madam Chairman.
Toby or
I think Andrea, yeah.
Andrea?
So thank you, and it's really a great privilege to speak here this evening in honor of Johnny Veeder and the wonderful book that Marie and Sam have edited, which compiles dozens of his articles, lectures, and speeches on a wide range of arbitration-related topics. And so thank you for the invitation, and thank you, Meg and ICSID, for hosting. So Johnny was really exceptional in so many ways, and it's fitting that this book captures that through Johnny's own words, by collecting and organizing his prolific writings on so many different arbitration topics. And Johnny found guidance through his painstaking, is that close? No? Okay, thanks. So Johnny found guidance through his painstaking historical research for the most vexing issues facing international arbitration. And this really underpinned his legal philosophy with a pragmatic aim of ensuring the sustained support for the resolution of arbitral disputes or international disputes by arbitration, particularly for those involving states. And Johnny's overarching conviction that the public's acceptance of the arbitral process was key to its continued survival is reflected in his writings as well as in his decisions as arbitrator. As Johnny remarked in his 2015 Alexander lecture, International arbitration cannot do everything, and we shouldn't stretch its limits to resolve disputes where there is only minimal consent and negative public support. So I first met Johnny when I was a much younger attorney at the U.S. State Department, and we appointed him as president of the Methanex Tribunal, to which Sam was secretary. And although none of us at the time knew Johnny or had worked with him, our research revealed his impeccable reputation for intellectual rigor, his unbiased assessment, and his strong values. He was universally liked and respected. And the interim decisions and final award in that case are classic and continue to be cited and referenced today. And his decision on transparency in the Methanex case marked the very first time that an investment treaty tribunal held that there was no duty of confidentiality and that amicus submissions could be accepted. And this, of course, predated the adoption of the NAFTA parties' Free Trade Commission interpretation on confidentiality and its guidelines on amicus submissions, and long preceded the amendment of various arbitration rules. The cornerstone of the tribunal's decision rested on its views that the tribunal had discretion to conduct the proceedings, subject, of course, to the requirements of procedural fairness and equality. And Johnny's hand in drafting this decision is evident. And we need only look at the reference to the fact that the London Times had contemporaneously published the Lena Goldfields awards and orders in 1930 in light of the public interest in that arbitration. So ultimately, Johnny's concern with ensuring that investment arbitration had buy-in from the public remained paramount, with the tribunal in that case noting that the Methanex arbitration was of interest to the public because of its subject matter, and that the arbitral process itself could be harmed if it was perceived as being unduly secretive. While Johnny was in the vanguard of certain reforms like increasing transparency in international arbitration, he believed that many of the other proposals floated to improve arbitration were misguided, because many would ultimately erode rather than increase the legitimacy of and ultimately widespread support for the process. And in his 2008 lecture, delivered at a conference organized by the late Emmanuel Gaillard and the International Arbitration Institute, for instance, Johnny advocated against a revision of the New York Convention. He rejected the possibility that a revision would lead to a good, practical, and more useful treaty. And to illustrate, he analogized the New York Convention to the Ten Commandments. His point was that we should no more redraft the Ten Commandments than we should amend the New York Convention. And neither could possibly resolve every query, but their texts are subject to reasonable interpretation and have served us well. The process of redrafting either, he explained, would likely lead to more debate and disagreement, and in his words, it could never lead to anything good or useful, or indeed anything. And in the same vein, public acceptance of arbitration cannot be gained by attempting to codify the content of every substantive standard in a treaty, or to regulate every procedural aspect of arbitration, and such attempts are bound to fail. In fact, Johnny pointed out the often overlooked value of intentional ambiguity in treaty drafting. Drawing on his research into the Alabama claims arbitration of 1872, Johnny elaborated upon the most divisive issue between the United States and the United Kingdom in that dispute, which was the United States' indirect claims. And those indirect claims were in the amount equivalent to $3 trillion, in $30 trillion actually in today's money. And they comprised consequential damages suffered by the United States as a result of Great Britain's failure to abide by its obligations of neutrality during the US Civil War. And chief among the claims that were advanced by the United States as indirect claims were for the damage sustained as a consequence of the prolongation of the US Civil War by approximately 2 years. And ultimately, the parties resolved this issue by arranging for the arbitrators to issue a declaration, not in the form of an order, a decision, or an award, that indicated that while the indirect claims were not necessarily outside the scope of the treaty, they lacked merit. So although this party agreement was reached at the highest levels of the respective governments, they needed the imprimatur of the tribunal's declaration, which didn't reveal that it was a product of the parties' agreement. This was needed for legitimacy and acceptance. So the intentional ambiguity in the treaty's language as to whether it covered claims for indirect damages proved critical. There would have been no treaty without it. And the most difficult issue ultimately was agreed to by the parties, albeit only once arbitration had commenced and the stakes were at their highest, and even then only with the cover of the arbitral tribunal. Where parties recognized ambiguity but choose instead to eliminate it rather than to leave it in the hands of the arbitrators, Johnny, of course, protected that choice. And the Menaker Tribunal was one of the first to consider the binding nature of the NAFTA parties' interpretation of the fair and equitable treatment standard. And more important than Johnny's professed agreement with the content of that interpretation was his explanation that was set forth in the final award. As the tribunal explained, just as a legislature might amend a law following what it believed to be a misinterpretation of that law by the courts, so too may parties interpret or even amend their treaty. And in the context of ruling upon the legitimacy of the interpretation when the NAFTA contained provisions providing for party interpretations, Johnny once again referred to the Alabama Claims Tribunal, which had confirmed that states may condition their agreement to arbitrate upon application of certain principles and rules of law. Johnny also found support in historical events for his view that party-appointed arbitrators were integral to the system of international arbitration. In several of his lectures and articles, Johnny observed that an overriding purpose behind party appointments is to provide each party with an arbitrator who understands it and can ensure that its positions are heard. But equally, Johnny appreciated that the real value in a party appointment is not so much that it gives a party a hope that it may win its case, much less that the party has someone on its side, because Johnny was adamant that all members of the tribunal are independent and impartial, or ought to be. The real value in party appointments was that their presence increases significantly parties and particularly states' willingness to arbitrate, as well as the likelihood that they will accept an adverse award and abide by it. And so, although Johnny characterized the appointment by Great Britain of, and I'll mispronounce his name, but Sir Cockburn? Coburn. Okay, the British drop a lot of consonants I've been discovering. So, Coburn. He criticized that appointment because he said that Coburn was outwardly partisan, and that proved counterproductive. But he held out the appointment as an example of the importance of party appointments. And Coburn proved his value in his dissent by imploring the British public to accept the adverse award as the decision of a tribunal by whose award it has freely consented to abide. And this is as true for investment arbitration as it is for state-to-state arbitration. In his article on party-appointed arbitrators, Johnny addressed the criticisms to this practice made by eminent scholars and arbitrators alike, and pointed to the United States' appointment of Judge Abner Mikva in the United States' first investment treaty tribunal case, in the Lowen case. And as Johnny noted, and I quote, "What better example to show Capitol Hill and news media hostile to NAFTA if the case had been decided against the United States, that the American arbitrator, as a publicly known legal and political figure, had jointly agreed on that adverse award with his two foreign arbitral colleagues." Johnny's appreciation for the critical role that party appointments have made to the acceptance of arbitration, no doubt in part motivated his objection to the investment court idea as a replacement for investment arbitration. Any investment court would be comprised of judges, all of whom would be appointed by states. And were an investment court to be established, Johnny thus considered that this would become an alternative to, but not a replacement for, investment arbitration. As he remarked in his 2015 Alexander lecture, arbitration would continue to flourish, whether as a product of concession contracts or foreign investment laws. Were this to happen, though, those arbitrations would proceed with less transparency than we have today in investment arbitration, and this would mark a retreat from much of what has been accomplished to date, and the legitimacy of and support for arbitration would diminish as a result. The European Union's and now the UNCITRAL Working Group 3's proposal for an investment court harkens back to the United States' failed attempt to gain acceptance for an investment arbitration appellate body. And in the early 2000s, I represented the United States at a meeting convened in Paris by luminaries in the international arbitration field to garner support for the United States' proposal. And over the course of a very, very long meeting, I was the only person in the room to speak in favor of that proposal. And among others, Johnny voiced his disapproval. And I only have the vaguest recollection of what anybody said that day, but I very distinctly recall one of Johnny's comments. And that's no doubt because when he spoke, it was always because he had something very interesting and very distinctive to say. And Johnny predicted that an appellate mechanism, if it were adopted, and even more so if the United States' proposal, which is now being considered to extend appellate review beyond errors of law to egregious factual errors, the initial arbitration would become like nothing more than a stepping stone to an appeal. Every word would be appealed. Tribunals would be second-guessed on their legal and factual conclusions, and the quality of the arbitrators willing to sit on arbitral panels would suffer as a result. And that would be reflected in the resulting awards as well. And so the system would inflict harm upon itself, right? Some of the very criticisms that led to the creation of an appellate body would be realized on account of the creation of the appellate body itself. But despite this and other challenges, Johnny remained optimistic about the future of investment arbitration. He understood the tremendous role that arbitration has played throughout history in peacefully resolving disputes, particularly among or with states. And in fact, in his ITA lecture in 2006, Johnny traced Peru's political instability to its military coup of 1968, which in turn he attributed to Peru's failure to resolve its dispute with Standard Oil. Had there been an investment treaty between Peru and the United States at the time, or a foreign investment law, or a concession agreement that provided for international arbitration, Johnny surmised that history may have taken a different course. And this worldview underpinned his support for, and indeed his support for changes to the arbitral process when he believed that they would legitimize arbitration, as well as his rejection of reform efforts that he predicted would undermine support for arbitration in the long run. So I'll end with just stating that I believe we all need to preserve what we've created while treading carefully with innovation, keeping in mind that arbitration is a creature of consent and that consent, particularly for investment arbitration, will dissipate without public support. Johnny's deep understanding of the history of arbitration, its foundations and governing principles, his intellect and his humanity, informed his views as to when change was necessary and when it would be harmful to increasing legitimacy of arbitration in the public's eye. And that goal remains critical today in light of the challenges that arbitration and particularly investment arbitration are facing. So Johnny left a really very important legacy in this regard from which we all can continue to learn. Thank you.
Thank you very much. Johnny was undoubtedly a visionary, and he had a particular vision of the conduct of international arbitration, and that's what I'm going to focus on. In Johnny, there was a unique coincidence between his personal traits, the way he lived his professional life, and his vision of the practice of international arbitration. It was a very particular vision, and it was infused with many profound concerns about our field. And that, I think, is a centerpiece of his legacy. It's a vision which we need to recall more than ever now. And the vision can be understood in four elements that I think were very, very critical to Johnny's approach. The first element was a profound trust and belief in international arbitration as a process. He felt very sincerely that arbitration was part of an international system to maintain peace and international rule of law. And just want to read one little excerpt because it sums up so much of his approach to this. In his 2001 Goff lecture, he emphasized this critical component, or this characteristic of arbitration, as follows. He said, in 1937, the ICC Congress met in Berlin, where its opening session was attended by the German Chancellor Hitler and his colleagues Goering and Goebbels. Even then, the ICC's new president, the American Thomas Watson of IBM, felt able to proclaim the keynote of the conference, World Peace through World Trade. Thomas Watson was right, but not as right as he would be 50 years later. The great cause today is the same, but still greater. Without world trade, there can be no world peace. International arbitration is the oil which lubricates the machinery of world trade. And the mechanics, the international arbitration practitioners, now deserve better practical guidance as to how to apply that oil. International commercial arbitration cannot wait another 50 years. That was the first element. And he preserved that faith and trust throughout his life. The second element is really very key. And that was Johnny's conception of the role of us lawyers in that international system. For Johnny, counsel are integral to the machinery of international justice and international rule of law. And through Johnny's eyes, counsel have a special status because they have almost a constitutional responsibility to the system. That is a big world vision. It's a vision of counsel way beyond the cut and thrust of an individual case, way beyond the idea of pleasing your client or trying to win your case. For him, counsel's role was essential for arbitration to actually operate, and that meant counsel had to live up to very high standards, and there were great dangers if those standards were not complied with. That is a big picture view that was dissipating in Johnny's time, and it's dissipated much faster since. It was an aspect where Johnny's vision was perfectly embodied by his own character as counsel. Johnny saw the practice of law as a true vocation. He was driven by high ethical ideals, by a respect for law itself, by a relentless intellectual rigor and intellectual curiosity and intellectual honesty. And he had a consequent revulsion to those in the field who were driven by money. Now, I have to say, when things got tough as Johnny's junior, and they often got tough as Johnny's junior, when cases were not going the right way, where people were misbehaving, and where life was tough, Johnny was known to turn to his junior and say, do you know, sometimes the only compensation is the compensation. But actually, in truth, Johnny had no obvious interest in the financial aspect of practice at all. He hated the idea that younger practitioners were increasingly motivated by large brief fees, and Johnny had no obvious interest in issuing invoices. There was a ceremony once a month in Chambers involving David Grief, who is here, senior clerk to Johnny, who once a month would turn up in Johnny's room and try to reconstruct with Johnny what Johnny had done over the last 4 weeks in order to send out invoices and billing. That was the second element. The third element was a belief in the fragility of the system, the vulnerability of the system. Johnny always said that the system will only survive if trust and confidence in it survives. And it was vulnerable to fatal blows. And those fatal blows were being dealt increasingly by us, by the people who are actually operating the system. And actually what he said was that we don't realize in our own time the damage that we are doing to the system. In a brilliant address to the ITA in Dallas, actually which Andrea has already mentioned, which came with the brilliant title, Why Bother and Why It Matters. Actually, I have to drop a quick footnote. Johnny often said it wasn't worth bothering. Another ceremony, which some people in the room will remember, which we had every year in Chambers, happened at the end of July. At the end of July, every year, Johnny would declare to Chambers that he was leaving. He was giving up practice, he'd had enough, he wasn't going to bother anymore, and we would all go to his room and dutifully bid him farewell. Until September, when he came back. In his lecture, Why Bother and Why It Matters, he said the following. He said, Yogi Berra got it wrong. The problem with déjà vu is not that you only understand the real message when you see it for the third or fourth time. The problem is that you cannot see déjà vu the first time. There are many problems in this world which could be avoided entirely if you could understand déjà vu before the second time or the third. The fourth time may be far too late. If we can, we should try to understand something that is happening now for the first time and try to fix it before it's too late, so as to avoid saying, like Yogi Berra in years to come, that we could and should have understood and done something now the first time, before it became déjà vu all over again. And for Johnny, what was going to be the déjà vu, what was happening now, which we were not recognizing now, but we would recognize in the future, was the damage that we were actually doing to our system. And that takes me to the fourth element, where that damage was happening. What was actually the cause of, in the end, in Johnny's last years, a pervading disillusionment with practice in international arbitration? He said, bad practices, like bad money, tend to drive out good. And the bad practices that he was concerned about are things which now we have to be concerned about ever more. Firstly, unethical lawyering and threats to self-regulation. For Johnny, there was a constant concern about lack of ethical guidelines for lawyers and for arbitrators, a problem that was expanding as the pool of lawyers and arbitrators expanded. He said in his 2001 Goff lecture, lawyers are not musicians or ballet dancers. A lawyer's training, skills and ethics are still essentially rooted in a national legal system, and it's far from clear how and to what extent national professional rules apply abroad to the transnational lawyer in the international arbitration process. But Johnny's concern was actually rather subtle, and that was, we survive in our system by self-regulation. The minute that we stop our self-regulation, others will regulate for us. And that's where the system will then decline. In his words, regulation may pass to state or regional regulators with less affection for the arbitration process. So the concerns were as follows: over-lawyering. Johnny hated what he said was churning by large law firms. The organizers have done some research, by the way. There is nobody in the room who's guilty of this, which is so I can talk about it freely. The idea of lawyers putting too many people doing thankless, useless tasks and billing too many hours on cases that didn't warrant it. Johnny famously said arbitration was becoming what he called arbitration by numbers. And it was a numbers game rather than a skill which actually didn't require billable hours, anything like we see. He hated witness statements being the product of lawyers. He hated witness coaching. He hated dependent professional experts. He didn't like document production. He didn't like the malign influence of third-party funding. And what he didn't like more than anything was vanity. One of his pet hates was self-congratulation. He hated LinkedIn. And that's again because of Johnny's own character. Johnny, for all his brilliance, had consummate humility. He was unassuming. He was instantly disarming. As Meg has described, however fraught a dispute may have been, however hard fought, when Johnny left the room, everybody liked each other. And they liked themselves, and they felt good about the system. It was never about him. It was never promotion of Johnny Veeder. It was never congratulation. There were no airs and graces. The fact that there were no airs and graces was brought home to me the first time I met him, back in 1993, as a young pupil in Chambers, being shown to the room of the great Johnny Veeder. I had heard so much about him. This was the great man, and I was going to meet him and pay my respects. And when the door opened, it was the aftermath of a huge and nasty explosion. The room was scattered with papers. You couldn't even get to his desk without stepping on files. There were books everywhere, and Johnny was nowhere to be seen. And as I looked around, after a long while, there was a muffled voice welcoming me that came from underneath his desk. Johnny was on all fours, rooting around underneath his desk, looking for a document, and proudly saying to me from under the desk, he'd had a bit of a clear out. No airs and graces meant no publicity, no self-importance. He always said to us, never trust professional directories like Chambers and Partners and Legal 500, never, unless you're listed in them. He hated Chambers brochures. I've said before you'll see the memorial to him in the book. It was Johnny's fault that Essex Court Chambers for many years thought that its Chambers brochure was incredibly successful and in high demand, not knowing that every time Johnny walked into Chambers, when nobody was looking, he would scoop all of them up and hide them. There is still somewhere in Chambers a large vault of hidden Chambers brochures. The point was that these values shaped practice for Johnny. They kept focus for him on procedural fairness, and integral to procedural fairness was how counsel conducted themselves. And on top of that was a value, above all, of human decency. For Johnny, that was central to the role of counsel. He hated the aggression that one sees between counsel. He hated the lack of professional courtesy, how disputes are aggravated by angry letters from one counsel to another. Johnny taught us as juniors, you never take your opponent's name, ever. Because it's never about your opponent, it's about the argument. He would never refer to the name of his opposing counsel. There was only once in all the years that I worked with him where he did do it, because he suddenly found in a case against Gary Bourne incredible humor in changing the name of Gary's firm very slightly and seeing Gary's reaction. It was a case where Gary was at Wilmer Cutler in Pickering, and for some reason Johnny insisted throughout long-running hearings in referring to William Cutler and Pickering. We had better points in the case, but the result was triumphant. Aside from that, he said, you never take your opponent's name. You will never use inflammatory language. You are always open and straight. And what he hated most were the little twists, which we see all the time now, where counsel will say, this argument from the other side is not only wrong, it's dishonest. People will say, this is deliberately misleading. This is disingenuous. Every time he heard that, he would bristle, because actually in Johnny's world, that was a serious allegation of professional misconduct. It added nothing. You can be right and you can be wrong. Why do you have to be honest or dishonest? The dishonesty icing, which we see all the time now, genuinely upset him. He was courteous to everyone he came across, whether it was counsel, arbitrator, whether it was opponent, junior, whether it was cleaner, whether it was child of cleaner. And actually, one of the best testaments to this was to read what Johnny wrote about one of his mentors. Johnny looked up to, as a role model, Robert Goff. When he gave the Goff lecture in 2001, it was telling how he described one of his own mentors. Johnny said this, he said, Robert Goff was one of the greatest advocates I have ever heard. He was a creative scholar. he was the most courteous judge. He is now a distinguished arbitrator. But above all else, he was and remains the epitome of fairness and human decency. To listen to his advocate's argument, even in the most contentious case, provoked no sense of ill will, just despair at the power of his legal logic. And to lose a case before him as a judge left only a strong sense of his intellectual honesty. So for Johnny, that was the standard that we all had to live up to, that he strove to live up to. And that was 2001, that lecture, where he went on to say, with great regret, that standard we were failing in. But that was 2001. And in all the years that have rolled by, Johnny saw us go deeper and deeper away from that ideal. And actually, that is something which I think, in terms of the Johnny Veeder legacy, is something most important. Something which we now have to bear in mind more than ever. It led Johnny to a belief in a duty of good faith in arbitration. It led him to a belief in mentoring, and he mentored more than anybody else. The mentoring happening in Johnny Veeder's his infamous room in chambers, which became a place of teaching for so many people. It also became a place of time suckage, a place where time behaved differently, where you would spend hours meaning to only be there for 10 minutes, where you would listen to tales of his life and other people's life. You would hear not only chambers gossip, you would hear about law, you'd hear about ethics, you'd watch him bash out his amazing articles with his amazing keyboard technique of 2 fingers impacting on a poor keyboard, long-suffering, and a thick, broad ink pen nib which distributed ink all over his hands and, amazingly, his cheeks. But that was mentoring that left its mark. And Johnny's regret was that we are now in a world where mentoring is no longer valued, and you can see it. In my tribute to Johnny in the book, I said that the world has not just lost a man, scholar, mentor, friend, and confidant. The world has lost the grace of a great soul. And I think what the world has also lost is somebody who maintained these incredible ideals. He saw them as integral to the survival of our system, the survival of international arbitration, and that was something we should strive for. And if there's anything that we walk away with and remember, then I think that is where he is missed more than anywhere else. Thank you.
Thank you, Toby. Thank you, everybody. I'll start by saying that what many of us like about international arbitration is that each case tells a story. There's a plaintiff, a respondent, or more. There's a project, there's a failing, there's hopefully a happy-ish ending. And Johnny loved the stories. He went beyond the stories in arbitration, and he liked to ground the stories in contemporaneous history. Not just the history of arbitration, but history, which added breadth and depth to his articles especially. So he would take an important international arbitration case, one that we always teach and is in a footnote after footnote, and he would bring it to life. So I'm going to speak briefly about Johnny as I still think our leading historian and raconteur. He also liked photos, so I'll have a couple. Exhibit A is the 1930 Lena Goldfields arbitration. Johnny wrote many pieces about this, and one is in the book. The title is The Lena Goldfields Arbitration, the Historical Roots of 3 Ideas. I think most people in this room know this, but the arbitration was brought under an ad hoc arbitration clause in a gold mining concession agreement between the English company, you can see share certificate there, Lena Goldfields Limited, and the United Soviet Socialist Republic. after the Soviet Union's appointed arbitrator withdrew, the other two arbitrators awarded Lena then about 13 million pounds, which today would be close to $500 million, as compensation for unjust enrichment resulting from breach of that concession agreement amidst Stalin's 1929 five-year plan. Johnny writes that the case historically, and I quote, remains a baleful monument to the absolute power of a state able by force alone to thwart the consensual process of international arbitration. But also, he wrote, juridically, over the past 65 years, its direct beneficiary has been the modern system of international commercial arbitration, to which the Lena Tribunal applied several innovative, thank you, and hugely important ideas. Now, Johnny picked three ideas for that paper: the application of general principles of law to a private law dispute, number one. Number two, the power of a truncated tribunal, number two. And number three, the related concept of competence. Now, important as these ideas are, Johnny focuses on the bigger picture, and I quote from his article. In the broadest sense, the Lena case represents the development of modern commercial arbitration, and its context is the economic and political history of Europe during the middle part of the 20th century, including years of unparalleled horror in the Soviet Union. It also remains a story with practical lessons for many in commercial arbitration and transnational trade involving states and state agencies, not limited to Europe. So you see from just that one quote that with Lena, Johnny ties arbitration principles, arbitration practice, and world history together. And thinking about it for tonight, it's not, I don't think, I never talked about it with Johnny, it's not that I think he wanted to teach international arbitration with a spoonful of sugar or lighten it up. He was genuinely curious about the context in which all these cases were happening. Now, on Lena, do not underestimate the work that went into his research on the case. I see Marie nodding there. The original award, we can show the second slide. Thank you, sir. The original award is filed in the Moscow archives, including parts that are missing from the only English version, which was printed in the London Times. This is it, from 1930. There is no existing English original of the award. The transcript, the papers, the photographs are all presumed lost somehow in World War II. With Marie Veeder and others as sleuths and translators, Johnny dug through, year after year, archives in Washington, England, Moscow, and Berlin. And he used Soviet documents that were prepared to defend the Soviet Union in the diplomatic controversy with the UK and Germany that followed the award, which Andrea alluded to. And there were legal commentaries by two Soviet professors who had served as legal advisors in the arbitration. So he checked the correspondence that they quoted against originals in archives, tracked down more documents when English, Russian, and German archives were later opened. Just skim the footnotes in his article to get a sense of the depth of his research, all in different languages, of course. So as Johnny writes, the story of Lena Goldfields Limited, the company, is, and I quote, a complicated story with roots in the early economic history of Soviet Russia preceding Lenin's new economic policy, intertwined with the UK's early diplomatic and trade relations with Soviet Russia, particularly Lloyd George's foreign policies. Now, he covers all this, of course, in a serious and learned fashion, as always, tying strands from arbitration law and practice into the events of the 1920s and 1930s. And bonus, knowing how important the actual people always were, he takes on the role of biographer. I refer you to Johnny's description of Lena Goldfield's counsel, Dr. Vladimir Robertovich Idelson, who escaped the Red Terror in 1918 for London and became the first foreign-born naturalized King's Counsel. Johnny describes him as still remembered in Lincoln's Inn as a large and likable character. He credits Dr. Idelson with the tribunal's application of general principles of law. And I think to capture the reader's attention, Johnny likens Dr. Idelson's internationalization of a transnational contract as, and I quote, a gigantic first step for international commercial arbitration, almost equivalent to the caveman's discovery of fire, end quote. Now, for the Soviet Union's reluctantly truncating arbitrator, that was Dr. Semyon Borisovich Chelnov, Johnny somehow found out that he was executed in 1937 for allegedly participating in a counter-revolutionary terrorist organization, secretly cremated, secretly buried in an anonymous pit under a Russian plaque which says, "May they never be forgotten." And Johnny writes, and I quote, "In that pit lie now the last earthly remains of Dr. Chelnov, a recalcitrant arbitrator despite himself and guilty only of living in the worst of times." Classic Johnny. I'll mention a second article, again, on Alabama. We can show you the infamous Alabama. This comes from the Alabama Claims Commission of 1872. Johnny took this on in the inaugural Brower Lecture at the American Society meeting back in 2013. The title is "The Historical Keystone to International Arbitration, the Party-Appointed Arbitrator from Miami to Geneva." I think everyone here again knows the background. Under the 1871 Treaty of Washington, Great Britain and the United States established a 5-person tribunal to arbitrate their dispute. And their dispute was this. Had Great Britain failed to meet its neutrality obligation by allowing the Alabama and other raider ships, very dramatic there, to be built in England and delivered to the Confederacy for war operations against the Union in the Civil War. The tribunal said yes, and as Andrea said, awarded a great deal of money, then $15 million, to the United States. But the outcome was not Johnny's only focus. As Andrea mentioned, he really focused on the procedural innovation, a first in modern times, where the U.S. and Great Britain appointed their own arbitrators to the tribunal, thereby creating the model that we all live with in every case almost today. And Johnny felt this was important because it creates a party's ownership of the process, skin in the game in the process. Now that would have been enough for a great arbitration lecture, but Johnny didn't stop there. He described not only the substantive legal conflicts, but the proxy conflicts in achieving the Treaty of Washington, constituting this 5-person tribunal, and the interactions, in Johnny's words, between the cold-blooded Charles Francis Adams as the U.S. appointed arbitrator and the warm-blooded Sir Alexander James Edmund Cockburn, and there he is, the British appointed arbitrator. Now, only Johnny would have gone on to investigate not Cockburn's opinions, but Cockburn himself. Because Johnny said he wanted to, and I quote, redress the balance to the extent possible, meaning not at all, Cockburn's description by Gladstone's biographer as being a natural, illiberal British chauvinist. So here's Johnny's description of this arbitrator's sideline. This is all in an academic article, by the way. And I quote, "Sir Alexander Cockburn had written a dark and morally troubled novel in his early days at the English bar, when his practice was non-existent. The novel was never published. It has no title. It's never mentioned in any public account of his life. It is now to be found in 19 bound notebooks written in his own handwriting in the archives of the Middle Temple in London. The manuscript seems untouched, save for 1.5 readers over 150 years, end quote. Now that last reader was Johnny himself, the half reader, and that's because Johnny admitted in his Brower lecture to the audience that he was unable to tell them the outcome of the plot. In Johnny's words, who was the departed Adele? Who was the blushing Felicie? Who was the mother of that baby son? Because Coburn's handwriting became so increasingly bad that Johnny had to stop reading at notebook number 9 of 19. Now, I have academic article, by the way, a speech. I've never been able to think about the Alabama again, however many times I've taught it or referenced it, without thinking of Johnny in the Middle Temple archives, surrounded and delighted by those 19 notebooks that he had somehow discovered after so many years. And so it makes me think, and many in this room think, who else but Johnny would have done that? And I close just by mentioning that Johnny had a great love, as you heard from Toby and others, about encouraging the careers of young lawyers and new lawyers to arbitration. And so I mentioned that through ICA, we set up these Johnny Veeder fellowships where we're giving micro grants to students, new practitioners, young lawyers who have a project going, but they need a little extra money in order to do it. We've had 2 successful years, and I just heard this morning that we have the next batch of applicants. So we consider this a great tribute to Johnny to know that younger people are being funded with that little extra plane ticket or computer or whatever they need to go out in the world and practice with the pride that Toby and others have described, that we all learn from Johnny.
Thank you, Lucy. I think we have a few minutes, and I wanted to invite anyone in the audience who has a recollection. Ron.
Is it on?
Yes.
It's on. Well, first, I just wanted to say what a wonderful presentation by the panel. I thought it was terrific. It reminded me by everybody of Johnny in the various things you talked about. I've known Johnny, or knew Johnny, for about 40 years. And in fact, the first, you talked about mentoring. The first time I met him, I was on the legal staff of something called the Iran-U.S. Claims Tribunal, and a judge at the tribunal named Howard Holtzman couldn't make it to an arbitration conference in Salzburg, and he said, "Ron, can you go and deliver the speech?" And he had it all written out, and I thought, yeah, wow, and I'm a year and a half out of law school. I'm thinking, yeah, go to Salzburg, sure. I go to Salzburg. I'm walking in the streets, a little worried now about this. It's an arbitration conference. I'm going to read a speech. And I think we had badges, so I meet Johnny in the street. He said, "So you're at that conference?" I said, "Yes." "Why are you looking worried?" I said, "Because, yeah, I can read the speech, but what if they ask me questions afterwards? You know, I'm a year and a half out of law school. What do I know?" He said, "Let's sit down." We sat on, I remember it was a wall in the street, and he said, "Tell me about the speech." And we talked about the speech. And he asked me a few questions that I answered. And he said, "You know what? You shouldn't be worried. You know more than they do." And this was the first time that somebody had given me that kind of sort of confidence that it might go okay. I got to the conference, read the speech. There was one question from Johnny, which, of course, I kind of knew about since we had talked about it. And I thought, that was mentoring at one of its best. But in the reception later, I can tell you, about more about, for example, the LCI swim team that some of us may remember. Synchronized swim team. That's what it was, Toby. And a few other anecdotes. I'll stop here just saying that he was an absolutely wonderful friend throughout the career. He was chair of 2 of the tribunals at which I litigated, 2 or 3, and always had a great respect for him and also great friendship, great love for him. Thank you all for doing all those things you've done.
Thank you. Does anyone else want to add, or do you want to wait until we have a glass of wine to share some more stories? John. Oh, good, John.
I'll just add, I had the great fortune 20-odd years ago, my first investor state case, to recruit Johnny to help me with the case. I was counsel, and he agreed to be co-counsel, and step by step guided me through the maze in my first case against the Russian Federation. I still remember after we put the first submission in, I was sitting next to my then new associate, Jim Boykin, and said, what's the most important word in this brief? And he looked at me blankly, and I pointed to Johnny's name on the cover. And I said, this is what's going to make the difference. And it got us. That's what got us listened to.
Good. All right.
Could I tell a little story?
Please do.
Okay, my name is Les Schiefelbein, and I'm from San Francisco. But I first met Johnny in 1992 or 1993, Toby, and I think I must have been the next one in the door. I arranged an appointment with him because at that time I was counsel for the Lockheed Corporation, and we had a very, very large satellite dispute. And Johnny was highly recommended to us to be our counsel. And went in, and it must have been the coldest and rainiest January in London, and I know the weather's like that all the time, but I live near San Francisco, and it's bright and sunny in the winter. So I was a bit taken back. I didn't know about the largesse of his reputation, I must say, when I first met him. But I was a bit taken back about how disorderly his office was and things like that. And thinking that this is really, really a big case. And if I put this case in this guy's hands, and we ultimately lose, I'm going to pay the price, okay? But during the time we chatted, we must have been chatting for about 2 hours. I must say we chatted very little about the law in the case, and we chatted more about myself and about Johnny. And we went on to retain him, and we were successful with it. But that's just the small part of the story, because from that day and for 30 years on, we remained very, very good friends. And I can tell from each one of the participants who said something about Johnny, it's kind of a reflection of the memory I have. And I wish to thank you for everyone that said, and this is really, really a very happy night to think about Johnny and flood your mind with all these nice stories. I learned more about the royal family. I learned more about the people who owned Harrods in those days and what they did and all the recent gossip and things like that. And it was just terrific. So thank you. Okay.
Thank you very, very much. Good. Well, then I will exercise my prerogative to pour a glass of wine for all of you, and we will go and have a toast. And I want to thank you all for being here this evening, and I look forward to chatting with you a bit more. Thank you.